We go now to Chapter 5, Liabilities of the Parties. Section 60. Liability of the maker. The maker of a negotiable instrument by making it engages that he will pay it according to its tenor and admits the existence of the payee and then its capacity to endorse. Okay. We already know before, we have discussed before in section 1 who is the maker. The maker is the one who issue the negotiable instrument. Who issue is the obligor, or is the obligation to pay according to the tenor of the negotiable instrument and admits the existence of the PA and his capacity to endorse. Okay, and we have discussed it already. So we go now to section 61. Liability of the drawer. The drawer by drawing the instrument admits the existence of the payee and his incapacity to endorse. A drawer again is just when we're talking about a bill of exchange, this is the drawer. The drawer by drawing the instrument admits the existence of the payee and his capacity to endorse and engages that on due presentment the instrument will be accepted or paid or both according to its tenor, and if it be dishonored and the necessary proceeding on dishonor be duly taken, he will pay the amount thereof to the holder or to any subsequent endorser who may be compelled to pay it. But the drawer may insert in the instrument an express stipulation negating or limiting his own liability to the holder. This is the right to put stipulation, negativity or limiting his capacity to the holder. Okay. Section 62. Liability of an acceptor. So, since another party to a promissory note, already discussed who is the maker and who is the drawer. When we're talking about promissory note, it is a maker. If we're talking about a bill of exchange, it is a drawer. But both of them are the one who issues the promissory note or the check and the obligor to pay. So remember that maker, drawer is the obligor. We go to section 62, liability of acceptor. The acceptor, by accepting the instrument, engages that he will pay it according to the tenor of its existence and admits A, the existence of the drawer, the genuineness of his signature, and his capacity and authority to draw the instrument. B, the existence of his payee and his incapacity to endorse. This is what we call, this is especially to the bill of exchange or a check. The acceptor is the bank wherein the check was presented. Okay? This is the acceptor. Section 63. When persons deemed endorser. A person placing his signature upon an instrument otherwise than as a maker, a drawer, or acceptor is deemed to be an endorser unless he clearly indicates by appropriate words his intention to be bound in some other capacity. So this is, if you are not the maker or the drawer, as we have said, they are the first party who issues, who draw the check, and the obligor. If you're not the acceptor, or let's say, like for example, in the bank where you accept the check, then you are considered as mere endorser. An endorser. An endorser is the payee, the next party. Section 64. Liability of irregular endorser. Where a person, not otherwise a party to an instrument, place their own signature in blank before delivery, is liable as an endorser in accordance with the following rules. So, nakiapi, sumali siya sa signature. A. If the instrument is payable to the order of a third person, is liable to the payee and also the subsequent party. This is when he signed the promissory note, even though he was not a party, original parties therein. B. If the instrument is payable to the order of the maker, or drawer is payable to the bearer, he is liable to all parties subsequent to the maker or the drawer. C. If he signs for the accommodation of the payee, is liable to the all parties subsequent to the payee. This is called liability of irregular endorser. An endorser wherein he signed on the instrument without any description of his capacity was capacity when he is signing the check. It depends on where did he sign. He signed for accommodation the payee. After the payee, he's liable. If he signed for to the order, he's liable to the parties after the make or the drawer. Okay. Section 65. Warranty were negotiation by delivery and so forth. Every person negotiating an instrument by delivery or by a qualified endorsement warrants: A. That the instrument is genuine and all respect without it purports to be. B. That he has a good title to it. C. That all prior parties have capacity to contract. D. That he has no knowledge of any fact which would impair the validity of the instrument or render it valueless. The provisions of subdivision C in this section does not apply to persons negotiating public or corporation securities other than bills and notes. Section 66. Liability of a general endorser. Every endorser who endorses without qualification warrants all subsequent holder in due course. The matter and things mentioned in subdivision A, B, and C in the next preceding section, that the instrument is at the time of his endorsement valid and subsisting, and in addition he engages that a due presentment it shall be accepted or paid or both, as the case may be, according to its tenor, and if it be dishonored, the necessary proceedings on dishonor be duly taken. He will pay the amount thereof to the holder or to any subsequent endorser whom he may compel to pay it. Very self-explanatory. Section 67. Liability of endorser where paper negotiable by delivery. Where a person places endorsement on an instrument negotiable by delivery, he incurs all the liability of an endorser. Where the negotiable instrument can be negotiated by delivery, then he has the liability of an endorser. Section 68. Order in which endorsers are liable. I respect one another. Endorsers are liable prima facie in the order in which they endorse. But evidence is admissible to show that as between or among themselves, they have agreed otherwise. Joint payee or joint endorsers who endorse are deemed to endorse jointly and severally. Meaning, they are liable jointly on the promissory note. Section 69. Liability of an agent or broker. Where a broker or other agent negotiate an instrument without endorsement, he incurs the liability prescribed by Section 65 of this Act, unless he discloses the name principals and the fact he is acting only as an agent. If an agent did not disclose his principal, then is liable personally to the whole amount. So the need of the agent or the broker to disclose the name of the principal is necessary in order for him to be exempt to personally pay the promissory note or the bill of exchange.